Hello, Your Honor.
Hello, your name?
Eric James Casey.
All right. Sir, you're here on an arraignment on two charges. The complaint alleges that on or about July 18, 2024, at the location of
This courthouse.
33.
Yeah, it all happened in this courthouse.
Are you going to interrupt me?
I'm sorry.
Are you going to let me continue with your arraignment?
Okay, I'm sorry, sir.
Which way you want to do it?
I'm not going to interrupt you.
Thank you. Complaint alleges that on or about July 18, 2024, at the location of 4133 Washington Avenue in Pittsfield Township, Washington County, State of Michigan, complaint alleges that you did make an assault and battery upon a Joseph Crossley. Do you understand the nature of that charge, sir? And I'm not asking you whether or not you did it. Do you understand what you were charged with?
Yes.
That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. This could be a consecutive sentence. And if a consecutive sentence can be imposed, if this did occur within a place of confinement, you understand the nature or the penalties in this case?
Yes.
You understand that?
Yes.
Count 2 on that complaint alleges that on that same date and at that same time, you did commit the offense of disorderly person jostling. Do you understand the nature of that, sir?
No, because I don't even know these people. The only person I know is Joseph.
Do you understand what you are charged with?
Well, I know what you're charging me with, sir, but
I am not charging you. Do you understand what you are charged with in count 2?
No.
All right. Let me just do it formally then. July 18, 2024, the location of 4133 Washington Avenue in Pittsfield Township, Washington County, State of Michigan. Count 2 specifically alleges that on that same date and at that same location that you were a disorderly person. To wit, a person was found to be jostling or roughly crowding people unnecessarily in a public place at that location. Do you understand all of that, sir?
I understand all this.
That is a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. Do you understand those penalties?
I understand this, Hunter.
Do you wish to be represented by an attorney?
Yes, I guess so, Hunter, because you're the
Public defender case.
Assistant Public Defender Natalie Pate, and on behalf of Mr. Casey, we would waive any further reading. My client stands mute, and we would ask for an adjourned pre-trial date as well as a PR bond, please, Your Honor.
Defendant having waived for reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be adjourned to July 16, 2025 at 9 a.m. I will set the defendant's bond in this case amount of a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of any weapons or anything fashioned to be a weapon. Do you understand that, sir?
Oh, yes.
Do you understand also that I am going to order no possession or consumption of any alcohol, recreational marijuana, or any illegal drug?
Yes.
I will also order that you are not to have any contact whatsoever with Joseph Crossley.
Don't want to. I'm sorry, sir.
You are really wearing on me.
I'm sorry, sir. I'm just trying to.
Do you understand the order? That was a question. Do you understand you are to have no contact with Joseph Crossley?
Yes. I haven't had no. I'm sorry.
He gets one more time.
I'm sorry.
I'm changing the bond.
I'm sorry.
Is there any other requests of conditions from the people?
There is a request for a no go to, Your Honor, an address. May I give that to the court?
No go to, yes, go ahead.
10245 Talladay Road, Talladay, in Willis, Michigan.
No.
48191.
Nope.
Any objection to that, counsel?
No, Your Honor.
All All right, I'm going to order that there is no go to that location, 1025 Talladay Road, Willis. Court calls case People versus Vincent Dunlap.
I think Mr. Stiller's on some of the other cases, but
Conrad Siller on behalf of Pittsfield Township.
sorry, Mr. Stiller, handling much stuff. Good afternoon, or good morning, Assistant Public Defender Lauren Perning on behalf of Mr. Dunlap on the cases ending in 0353 and 0354.
Good morning, Your Honor. The please is honorable court, Brandon Bird on behalf of Vincent Dunlap on the case ending in 0589.
All right, and what are we doing?
Oh, Your Honor, respectfully, got to speak with brother prosecutor and counsel over here, and we would like to plead all three cases to the civil infraction of a double parking.
That's correct, Your Honor.
Yeah, there's a state case, but that wasn't part of any resolution I was involved in negotiating.
I'm not a prosecutor. Dale fraud case. I'm only a prosecutor for the EWS case. And
That's why I thought I spoke with you earlier. Awkward.
well, it looks like we do not have an agreement.
Your Honor, respectfully, can we adjourn this matter to see how his other felonies play out? I know his preliminary exam got pushed back. Last time we adjourned it to see what was going to happen.
Do you want to adjourn yours out?
Please, Your Honor.
I have July 16th or August 6th, which is the preference if you're trying to time it up with an exam date.
July 16th, Your Honor.
July 6th. This being case 589, I'll adjourn that matter to July 16th, 2025, 9 a.m. Bond on that matter will continue.
My cases are the cases with Mr. Stiller, Your Honor, so I would, we are going
Double
to.
parking on both.
Correct.
And double parking in each case, Your Honor. Going to look at count two in each case, double parking. If you accept that admission fee in each case, and it's the original charge in each case.
That's a correct statement.
That is, Your Honor, thank you.
Dunlap?
Yes.
In the case ending in 353, do you admit responsibility to the fact that on April 2nd, 2021, Pittsfield Township, that you double parked a motor vehicle?
Yes.
On the case ending in 354, on the date of April 2nd, 2021, do you admit responsibility to the fact that you double parked a motor vehicle in Pittsfield Township?
Yes.
Court will accept those admissions in each case. Count two, count one is dismissed. In each case, fines and costs are $180, so that's a total amount of $360. That's to be paid 60 days. I'll make it 90 days after release.
Thank you, Your Honor.
Thank you.
All right.
Court does call the case of the People versus Juliet von Oceanbear Martinez. This is Mr. Siller's case.
Conrad Siller on behalf of Pittsfield Township.
All right. Ma'am, can you state your name, please?
Devin Julia Martinez.
All right. Pardon? Yes. Mr. Martinez, this is an arraignment on a misdemeanor complaint that alleges that on or about May 18th, 2025, at the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you were in possession of drug paraphernalia. Do you understand the nature of that charge, ma'am?
Yes.
That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court cost, and any substance abuse counseling the court deems necessary. You understand that?
Correct.
All right. And my first question to you is, do you want to be represented by an attorney?
It isn't
Pardon?
necessary. It isn't
Is it
necessary.
necessary?
It isn't necessary.
Well, it might be.
I said it isn't necessary, so could I just speak for myself?
Okay, what do you want to do on the case?
Just let me think.
Hey, Ms. Martinez,
Yeah,
are you still, you had other cases a while back. Are you still on probation on those cases?
no,
Okay, so you're not before the court, a court on any other things?
I am. But none of them are job related. And they're about to be finished.
Well, maybe. What other courts are you before, Ms. Martinez?
Is it necessary to expound upon this?
Pardon?
Is this relevant?
Well, it could be, because you could be facing additional sanctions depending on those cases, depending on what happens in this case.
Well, is there any way to lay this down? Like have it like
To do what?
have it go like is there any way to like forget about this somehow? Is there anything that I can do like community service or something that could do instead of
Ms. Martinez, you don't have, that's why I think you would need an attorney. I mean, you can proceed on your own if that's what you want to do. But quite frankly, me knowing a little bit about your history, I don't know that would be a wise call on your part.
guess so. Like what like I suppose.
Ms. Martinez, just answer me this. Are you represented by the public defender's office on your other matters?
Yes.
Okay, don't you think it might be wise if they help advise you on this matter and also help you with those other matters? Doesn't that make sense to you?
In a way.
In a way. Okay, in a good way?
In a way that is like I can have this be adjourned with a bond. Can I know what the bond is?
Ms. Martinez, I don't even have a plea from you at this point.
Oh, please, I'm guilty.
No, I didn't mean that.
Oh.
So,
I'm not protesting to the allegations. I would like to
well,
just,
hold on. I don't want you saying anything about the offense.
well, I do. I see no way around it. It's plain and clear and simple. And
Well,
there's-
I know that, and that's why people get attorneys, because sometimes they don't see any way around it.
but it's clear. It's plain. Like, really.
Well, I don't know that, Ms. Martinez.
Yeah, I guess I'll go with a lawyer, sure.
You will? Good. Okay, public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Martinez, Your Honor, we would waive any further reading. My client stands mute and ask that a not guilty plea be entered. I would ask, Your Honor, for an adjourned pretrial date. However, a more lengthier adjournment. The public defender does represent Ms. Martinez on her other matters. She actually has been referred to the Forensic Center and does have an appointment today with them.
Got
So
it.
I would ask for a lengthier adjournment to that end, Your Honor.
You should have led with that.
That's right.
All right.
The appointment is today?
When she has the appointment today?
It's scheduled for today per the letter from the center.
Got it. Do you know when the hearing date is set on the other matter?
Her latest court date in circuit court is July 28th, and her bond is denied on that case. So
Got
I
it.
believe it's the 28th.
Okay, so what I will do is I'll adjourn this matter out to August 6, 2025, 9 a.m. I'll set the defendant's bond so that she's getting credit because she's being held on that other case. I'll set her bond at a $5,000, 10% bond on this case. Order standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or any illegal drugs. All right, thank you.
Thank you, Your Honor. Thank you, Ms.
Does-
Martinez. Well,
Miss
well, I'll
Ma'am,
be down.
it says on the Forensic Center is coming to see me today?
It's scheduled for today, but I'm not sure if maybe I don't have the most updated information. So there's a chance it might be rescheduled, but from what I can see, it looks like it was scheduled for today. But either way, we'll be in touch, Ms. Martinez. But you're all set for court here today.
What is your name?
We're all set for court here today, Ms. Martinez, but I'll be down to see you before August.
Okay, but what is your name?
Oh, sorry, Natalie. I did not hear. I apologize, Natalie.
Natalie who? Natalie who?
Natalie Pate.
Kate. Thank you.
All right, thank you.
Thank you, Ms. Martinez.
Court does call the case.
This courtroom session highlights something we see again and again. Cases aren't just decided on facts, but also on behavior, decisions, and understanding the legal process. From interruptions and confusion to nearly pleading guilty without advice, multiple moments here could have gone very differently. The judge maintained control, clarified the charges, and ensured proper legal procedure was followed, but not without visible frustration at times. And in the end, both defendants are left facing ongoing legal battles, strict conditions, and uncertain outcomes. It's a powerful reminder: what you say and how you act in court truly matters. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.